A very good morning and a very warm welcome and joining with Law and Order, your program where you'll be educated with the legal scenarios. And as I said before, not knowing the law is not an excuse. So you have to know the law in order to properly proceed with any legal consequence. So today also we are going to move ahead with the continuation of intellectual property, and to do the honors with us we have Ms. Aparajita Aridas, Madam Attorney at Law and Chairperson for Lanka Intellectual Property Organization and Advisor for the Bangladesh Intellectual Property Development Program. Thank you very much, Madam, to be on board, and it's a pleasure to have a discussion with you. Right. Okay. So we discussed intellectual property, certain areas with regard to those things, and how can we enforce an action with regard to intellectual property, Madam?
Yes. When it comes to intellectual property, the main principle is unfair competition and undisclosed information. Unfair competition means the competition should be unfair, right? So, if the competition should be unfair means if a person who makes false representations, misleading the customers, and if he is carrying on dishonest practices in the trades, whatever the trade they do, the other person, the person who deprived, can take an action under 160, section 160 of the Intellectual Property Act. They can take an injunction as well as they can claim damages in the same case. Beauty of this intellectual property enforcement is usually in a normal civil case we can't have the damages along with the interim injunction. But here the beauty of this case is that you can institute civil action, commercial action as well as criminal action. As an example, when you take civil action, commercial action, you can take both the actions, claim damages plus claim for interim relief, injunctive relief. Injunction means you are preventing that person from doing the whatever the action. Criminal action, of course, as an example, I have published a book, right? You slowly counterfeit that and you have a massive amount of books in the PETA market, right? I can sue you by way of instituting civil action to claim damages and stop you from that. Along with that, I can take the police and I can institute the legal action in magistrate courts and arrest the goods which you have already counterfeited. So that is the beauty of this case, all in one.
All in one. That means, Madam, for the same scenario, two different actions are proceeding at the same time.
You can.
Right. So one in a separate court and one in another court, same thing proceeds for the same thing. And even will it avoid the principle like we can't impose any other action one after the other or something?
that principle doesn't apply here. That is not applied here because you can institute both the cases simultaneously because it's a criminal offense as well as a civil offense. That is the beauty of this law actually.
So when it comes to, Madam, the law of copyright, if my book is printed with massive number of copies or even photocopied for a certain economic purpose, it's been misused. So as the author, how can I proceed with the legal action?
Actually, as I told you, there's authorship right and ownership right. So when it comes to the author, you have to be very careful. Actually, this is all depending on the scenario of the case. We can't say one-to-one answer. If you are the author and the owner of the book, you can institute legal action. But the real scenario is not that. No, I write a book and I give it to a publisher, and publishers are the people who are publishing. So anyway, my authorship has been transferred. Sorry, my ownership is there. My my authorship is there, my ownership has been transferred. So I get a royalty for that, for my authorship. But ownership is with the publisher. So publisher can institute legal action. That is the difference. You have to be very careful, like swan who separate the water and the milk. So you have to be very careful in that.
We have to find the criminal thing there, the what do you call, how to institute the civil thing. We have to sort it out very clearly. And when it comes to another scenario, madam, industrial design created by myself for a particular process or to facilitate any other process that has been stolen by someone. So that belongs to intellectual property or theft?
No, the thing is, industrial design are not patents actually. You messed up the thing a bit.
Right.
Stolen in the sense, what do you mean by stealing?
Taking it into their possession.
Yeah, that is theft actually. I have this, you rob this. This is a intellectual property. No, this is a industrial design. Actually, these classes with these brand names, they have separate designs. So you rob it means it's a different scenario. It's a different scenario. It's theft. But the thing is, like in other countries, we use this term intellectual property theft also. But here, of course, we don't use the term theft. But the thing is, like when you take, actually you have to adhere to these principles. Unfair competition should be there. Now, I have this book with me. You take it. That doesn't mean you took my intellectual property. Right? So it's a different scenario.
Different thing. That is what we have to sort it out. So when it comes to sorting out the criminal intention and the civil thing there in order to proceed, can you just give us a certain example how to differentiate that criminal thing and civil thing?
Actually, criminal thing has nothing to do with this, right? So when it comes to intellectual property, the enactment itself says, look here, if it is a counterfeit, the client can take criminal action by way of a magistrate court to arrest those goods and take those goods into custody of the magistrate. Civil action says, look here, you can simultaneously claim for damages as well as get a injunction. So that is a separate law. That is criminal procedure. This is civil procedure. But the thing is, when you institute legal action for a counterfeit product to get the products arrested, criminal procedure applies to that court case. Because we are instituting the action in the magistrate court, no, when you want to arrest the goods. So in that case, criminal procedure applies.
Right. So with that, I think our viewers might have a clear understanding about the consequences, how to apply that criminal part and the civil part appropriately, taking that circumstances into consideration. So madam, we talked about damages and injunctions taking at the same time. So what sort of damages can we obtain? For a certain example, can you just, because this is a wide area, a practical subject, and even the cases different from one another, even the same thing, the same company, same names might be different. So it's difficult to give a generalized answer. So can you just explain, confine it to a small area?
Yeah, damages in the sense, I'll explain it by way of a scenario. Now as an example, I have a product. Right? I have a product, you copy it. You copy the trademark. I sell, you also sell. I am gaining a brand name like XYZ. So I've been using the brand name for a while and my product is very popular among the consumers, and okay, fine, I'm happy with the product. Same time, after some time, you use your name similar to my name. Then what happens? Customers thinks that it's my brand which has the popularity in the trade. Then what happens is customer used to buy your product instead of buying my product. Right? Usually these counterfeits are the price is lower than the original product. So that means you hit the original owner's market, share market, share value. share, the market share in the business, right? Then you are doing a dishonest act which creates unfair competition. Then I can claim damages because you are damaging my name, you are diluting my name, you are using my trademark, you are damaging my trademark and you have changed it. So, I have a right and I can claim damages from you because you are making a damage to me.
For that damage, that means that person making a damage is liable to pay the damages for the other party.
Yes, the person who infringe, that is the term is the person who infringes the owner's rights. He has to pay the damages to the owner if he has infringed the rights of the owners.
So, when it comes to proving the infringement, what is there any burden of proof or any other related consequence?
Actually, when it comes to patents, burden of proof is negative burden of proof. The person has to come and say, okay, fine, I didn't do it. But when it comes to the trademarks, copyrights and all, we have to prove, the plaintiff has to prove his case. Because now when it comes to trademark, the brand is all over the market, right? You have the brand registration. Even you can register or not. As long as I can prove that I earn money, I had a market share, I can, claim for the damages. I have to prove. The plaintiff has to prove the burden of proof goes to the plaintiff.
It's up to the plaintiff to prove that this has happened to me, right? So, madam, when it comes to this scenario, intellectual property, undisclosed information play a vital role. So, can you just explain a little bit about that?
Yeah, good question. So, undisclosed information most probably comes with employees. With regard to now, when it comes to technological development and the digital economy, there are a lot of employees who have trade secrets, so undisclosed information in their hands. As an example, there was this case, so I will explain along with the case. Actually, I can't use the names. It's a very popular cough relieving medicine in the sense Ayurvedic medicine, very popular. Still we drink. Actually, it's a really good product. So what happened was the main storekeeper, CEO, and the whoever resigned from this particular company and started their own business along with this particular. They manufactured this particular product. What happened was this particular company sued the other company who copied the product. Actually, they have not patented this. Actually, patenting is not compulsory. What happened was they went to courts, the original person who owns the product, and actually they proved by way of a chromatographic test. Chromatographic test in the sense like in chemistry, when a solution is there, if you want to prove that solution is the same solution in this, there is a particular test called chromatographic test. So, by way of that chromatographic test, they proved this particular product is the same. Right? Then what happened was the people were sued under trade secrets as well as unfair competition.
That means, madam, there were undisclosed information for particular product, and somehow at a certain scenario we have to disclose them in order to gain the the legal protection. Is it correct?
No. Disclosing undisclosed information is a wrongful act. That means it's illegal. As an example, you are a software engineer, right? You work in my company, right? I you resign from my company and you get the same coding what you used in, I mean, so for software, of course, you use coding now to make your softwares. So you use the same source code in for another business which you created. That means you are disclosing undisclosed information. Actually, this is very common in the IT industry. They are getting non-disclosure agreements signed by the employees. Non-disclosure agreements means actually for these undisclosed information. If you are a major company which has a lot of secrets, trade secrets in your company, from your employees, you have to get non-disclosure agreements, not to disclose your customers, maybe your customers. Actually, these laws, of course, are interconnected with all the businesses and data. So why we do this is to protect your data. Actually, when you expand the subjects, like when you interconnect the subjects with the scenario, now the data business is the major business now, like big data. Selling big data is the main business. So disclosing information is a, wrongful act, it's illegal. So in order to protect your company, you have to have non-disclosure agreements. The information which must not be disclosed, if somebody discloses the information, it's a wrongful act.
Wrongful act. That means if an employee working in that particular company signs that particular agreement, although he doesn't sign such an agreement, he might be liable for disclosing that undisclosing information.
Exactly.
Trade secrets and everything, is that particularly undisclosed information or any other difference between them?
No, trade secrets are intellectual properties of a company. As an example, I don't know whether it's the most expensive trade secrets, one of the most expensive trade secrets in the world is what?
Without saying the brand, it's a beverage.
Yeah, whatever the formula. Right? So there are a lot of formulas which are secret. Still the secret formulas are secret. So you have to protect the secrecy.
So madam, like when it comes to those secrets, there is a secret formula. And in order to prove that is, if it is a beverage or any thing that we consume, we have to prove it using certain tests. So if I'm formulating a new formula, I have to prove that this is good for human health, this does not damage any person. So with that trade secrets, how can we disclose that this is good for the health and everything?
No, the thing is, even though the formula is not disclosed, good question. Actually, the trade secret law sometimes that may be detrimental to the consumers' rights now, as an example. But the thing is, like when it comes to their standards, there may be standards for a beverage. So they must have taken those standards, like there are quality standards. So as long as they are in compliance with the quality standards, formula doesn't matter as long as it's healthy. But the thing is, you can argue in both ways. Because this is a wide subject, and as that in a previous case with I read the formula that with a thin layer, the chromatography techniques might be the thin layer chromatography, and there are certain other subtypes as well. So with that proving ability, we can prove the efficacy and efficiency and even the consumer friendly nature of those products without revealing those trade secrets. Okay, madam, then when it comes to trade secrets, if they are disclosed, and even if that trade secret is proven to be harmful for the people, so is that case proceeds in an intellectual property manner or in any other manner? It's actually consumer matter.
It deviates from this.
It deviates. The thing is like you can't divide laws. You know,
Yes.
all are interconnected, and you
Connected.
have to be very analytical to understand. Actually, in this type of a case, of course, you have to take a consumer action against that.
Can that revealer who disclosed that formula or the trade secret take the defense that I revealed this because this is harmful for the human health or this cause any other damage?
Yeah, that's a fair defense.
Yes.
That's a very fair defense.
Fair defense that in a certain ground, if it is fair, we can just move on with that.
Probably yes.
Yes.
That has to be argued a lot.
So when it comes to madam patenting, so if something of novelty and industrial applicability, there are certain things that we discussed in our previous episode. If we are creating a good creation, how to apply for that patent and how to move ahead in order to take that proper documents created. So as you are an expert in this area, can you just give a comment for novel innovators to proceed in a more legitimate manner?
Legitimate in the sense, my personal experience with this patent is that lot of scientists try to do the patent on their own. That's why they fail, not that they are inefficient or no, there's no efficacy or novelty or whatever. There's nothing as such. So my advice is to get the help of an expert, especially with patents, because now if you go to National Intellectual Property Office, you are given the application and all the instructions. So anybody will may be able to think, okay, we also can do, why we are paying for the lawyers, right? So instead of paying a thumping amount of money for the lawyers, okay, we'll do it. But the thing is, you will fail. That's why there are a lot of applications, patent applications to National Intellectual Property Office, but the failure rate is, I think, more than 75%.
75%. That is because of the inappropriate procedure followed.
Not the procedure. Procedure is appropriate because procedure is done by the National Intellectual Property Office. But the thing is the documentation. Right. So now when it comes to industrial design, there's a difference between industrial properties and patents. So you have to know it properly, because when it comes to patent, it's a universal patent you are getting. So when it comes to a universal patenting, they check for a lot of things, because all these scientists who are in the National Intellectual Property Office, they will check, they will examine your your novelty, industrial applicability, and inventive step. So you can't just have a product and fill the application and do some write some scripts, and you can't get a patent. That's the main problem with that.
Yes. And a simple question at the end, madam. If I'm applying for that patent, if I fails in the first step, can I reapply?
Yeah, you have a actually initially what National Intellectual Property Office does is that they will advise the applicant. If there are defects, of course, they really advise. Actually, they are very helpful, and they will advise you. These are the things you have to be done.
Right.
But the thing is, a lot of people, they try to do the drafting on their own. Sometimes they don't prototype. Prototyping, now when it comes to a industrial design, you have to give the prototype to the people. So you have to do a proper prototype along with all the specifications, details, so on and so forth.
Right. So with that, we had a good discussion, a fruitful discussion, and thank you very much, madam, for enlightening us with those areas as well. So if you are a novel innovator, if you are inventing something new, because we find certain university students and many other people from Sri Lanka, they invent new things. So if you are to proceed for a patent, that is the legal way, you have to follow the proper procedure and get the formal advice from an expert. So thank you very much, madam, once again, Madam Aparajita Aryadasa, chairperson for Lanka Intellectual Property Organization, for joining with us with today's program. Thank you very much, madam. And for the viewers, thank you very much for joining with us with the program Law and Order, you'll be able to gather more knowledge and more examples for the legal scenarios that we are demonstrating for you all to proceed the future in a successful manner. Thank you very much for watching. Stay tuned and have a pleasant day.